muita satisfação, o Comped comemora a presença de cada pesquisador e pesquisadora participantes do nosso 5º encontro virtual. Serão dias de muito aprendizado, troca de conhecimento e experiência, formando uma grande rede de pesquisadores com a presença de instituições de ensino do Brasil e do exterior, impulsionando cada vez mais a pesquisa jurídica nacional. Para que os próximos dias sejam proveitosos, o Comped gostaria de ressaltar algumas dicas valiosas. Confira o hot site oficial do evento. Nele você encontrará tudo o que precisa saber para participar do 5º encontro virtual do Comped. Acesse agora mesmo a programação completa do 5º encontro e organize sua participação. Não esqueça que os painéis serão realizados sempre nos períodos matutinos, já as apresentações de artigos nos períodos da tarde e de pôsteres sempre a partir das 18 horas. No hot site você também encontra a relação completa dos trabalhos aprovados e seus respectivos dias de apresentação. Confira também os manuais de apresentação com informações detalhadas de como proceder para acessar cada sala virtual do evento. Na hora de apresentar seu artigo ou pôster, busque sempre chegar na sala virtual com antecedência. Espere os monitores do Comped aceitarem sua solicitação e aguarde os coordenadores passarem as instruções sobre as apresentações dos trabalhos. É fundamental que cada participante confira o funcionamento do seu computador, tablet ou celular, assim como conexão, webcam e microfone. Esses requisitos são básicos para a participação em nosso encontro. Qualquer dúvida ou problema, procure em nossas salas virtuais um monitor do Comped ou envie para o e-mail secretaria@comped.org.br uma mensagem para que possamos ajudá-lo da melhor maneira. Bem-vindos ao maior encontro da pesquisa e da pós-graduação jurídica nacional. Não deixe de seguir o Comped nas redes sociais e ficar por dentro de tudo o que está acontecendo no 5º encontro virtual do Comped.
Bom dia a todos e todas. Eu tenho o enorme prazer em dar as boas-vindas nesse painel que eu tenho o prazer de coordenar com os nossos ilustres convidados, o professor Jairo Lima, a professora Marieta Safta, que eu farei as apresentações. Vou lembrar que é um painel sobre as respostas judiciais à pandemia do Covid-19. É um painel em inglês, eu farei as apresentações em inglês também, mas dou as boas-vindas a todos que nessa manhã de sexta partilham conosco o espaço virtual. Foi a opção que o nosso Comped, como viram na apresentação que me precedeu, teve para realizar no ambiente da pandemia. Decreta-se um fim da pandemia, entre aspas, mas ela ainda está aí. Então, é a maneira que nós conseguimos realizar o nosso grande encontro. É o 5º encontro virtual. Eu estou responsável por esse painel. A nossa ideia eu farei a apresentação dos nossos ilustres convidados e vamos pela ordem nas apresentações do professor Jairo e da professora Marieta. O professor Jairo Lima é professor, doutor pela Universidade de São Paulo e é professor hoje, onde teve o seu doutorado, e é professor na Universidade Estadual do Norte do Paraná. Já participou de uma série de eventos no nosso Comped e é uma pessoa que dispensa maiores apresentações, tal a sua inserção no meio acadêmico. A professora Marieta Safta é nossa ilustre convidada. Ela tem um currículo que nos obrigou a pedir uma redução para poder fazer uma apresentação dela. Ela é doutora pela Universidade de Bucareste em estudos econômicos, é professora associada na Universidade Tito Maiorescu, também em Bucareste, e foi primeira assistente magistrada na Corte Constitucional da Romênia. So let's start the presentation in English. This is an English panel in our 5th edition of the Comped, the virtual edition. Comped is the largest law institution in Brazil, and I have the pleasure to be coordinating this panel, which we pretend to discuss the judicial responses to the COVID-19 pandemic. We have two very well-known persons here to share the panel. Professor Jairo Lima, that participated in several other editions of the Compedi. He is a doctor. He has his doctorate degree by the University of São Paulo in the Faculty of Law in São Paulo. And he is by now a professor in the State University of Northern Paraná. Professor Jairo, it's a pleasure to have you here once more. And our Professor Marieta Safta is our guest. He is from Romania. We were talking in the backstage. I had the pleasure to be several times in Romania about 10 to 15 years ago. And she has a great curricula, but I'll just put a highlight in the main positions. It's a pleasure to have you, Professor Marieta Safta. She has her doctoral degree by the University of Bucharest, Romania. She is by now an associate professor in the Tito Maiorescu University, also in Bucharest, Romania, and she was first assistant magistrate at the Constitutional Court of Romania. My role here is just to give some coordination to the panel, and then we will have the special presentations by Jairo Lima and then by Professor Marieta Safta. We'll have room, I consider, to some questions, some discussions, because we are planning to end this panel by 11:30 maximum. So, as you know, the pandemic of COVID-19 was something, and this something by now that put the world upside down. All the countries in the whole world, all the population suffered the consequences of that horrible disease. And as a classification, as you know, a pandemic is something that is spread out all over the world. So every country in the whole world in almost 2.5 years tried to confront this horrible situation, the horrible disease, with millions of persons affected and millions of persons dead. So we are focusing in this panel just to say a little bit, but it's very important to share our research in this panel about the judicial responses to that pandemic. So we will start with Professor Jairo Lima. The room is yours, Professor, and then Professor Marieta Safta. I have the pleasure to have the Compedi board in the stage, and if we have any problem, Jonathan is acting to help us at the moment. Thank you, Jonathan. Thank you, the Compedi board. So, Professor Jairo, the room is yours. You can proceed. Thank you very much.
Thank you, Professor Rubens. Good morning, everyone. I am Jairo Lima, as Professor Rubens said, constitutional professor at the State University of Northern Paraná in Brazil. And I would like to express the great honor I'm feeling for being part of this panel on judicial responses to the COVID-19 pandemic. In special, I express my gratitude to Professor Rubens Bessac for inviting me. Professor Bessac represents for me the best gift I had in my PhD, as it's always wonderful to share with him the same activities. Thank you so much again, Professor Rubens. Besides, I would like to greet Professor Marieta Safta, who has been a great friend and a brilliant partner in the dialogue between Brazil and Romania. You are always welcome here in Brazil, dear Professor Marieta. Well, guys who are watching us in this panel, I would like to offer here a brief panorama of the responses the Brazilian Supreme Court gave to the constitutional issues emerged by the outbreak of the COVID-19 pandemic. As you know, the COVID-19 pandemic represented a difficult task for public authorities across the world. From quarantine orders to vaccination logistics, the pandemic outbreak forced governments to take decisions that sometimes could exceed the constitutional framework. Because of this complexity, this situation can be evaluated by different constitutional perspectives, by focusing on the balance of powers, the state of emergency, and mainly by the role of courts. So, here today, we have this dialogue between Brazilian responses and Romanian responses. And considering that the Brazilian Constitution and the Romanian Constitution establish an extensive list of fundamental rights, considering that the Brazilian Supreme Court and the Constitutional Court of Romania, are institutions in charge of safeguarding the Constitution with erga omnes and binding decisions, and taking into account that both are responsible for judicial review of executive and legislative act. Considering that facts, I opted to deliver here a perspective that demonstrates the role played by the STF in the pandemic, to highlight the responses it gave to the crisis. However, considering the high level of judicialization of politics in Brazil that we are already aware, and the consequent great amount of cases issued in the STF, I direct my talk to focus on the responses the STF gave to cases challenging acts of the President Bolsonaro. The reason for the choice lies in the fact that President Bolsonaro publicly denied the danger of the pandemic and continuously asked the people not to stop their daily activities only because a tiny flu. Besides, the way the STF dealt with these cases could represent an identification of its independence from the government. So I selected here just 3 cases to demonstrate some engagements of the STF court. The first case I will mention is related to the right of information, and it is the case ADPF 690. What's the case about? On June 2020, the National Health Department of Bolsonaro government intentionally deleted the data on the number of deaths caused by the pandemic. The official website stopped sharing important information such as the evolution curve of contamination and the graphs on the situation in each state member. The decision of the health department was taken concurrently with the change in the time of publication of the pandemic daily bulletin. Before that fact, the official bulletin was released between 5 and 7 p.m. and suddenly was changed to 10 p.m. The reason for that change lied in the fact that the Brazilian mainstream TV news are broadcasted between 8 and 9 p.m. And because of the increasing number of contamination, journalists tended to highlight the omission of the president to face the problem. In delaying the release of daily bulletin to 10 p.m., the government would avoid criticisms in the main TV news. Therefore, both measures aim to make the access to public information more difficult and then prevent the government from critiques. In face of this case, the STF struck down the actions of the health department and then decided for the maintenance of the full disclosure of data because, according to the Brazilian Constitution, public administration should be guided by transparency and publicity of its acts. Therefore, for the STF, it was unconstitutional the way the health department was omitting the situation of pandemic crisis in Brazil, just to preserve the image of the president. The second case represents one of the biggest enemies of the President Bolsonaro in his government, which is minority groups. In our specific case, indigenous rights. Considering that indigenous people in Brazil are especially vulnerable to infection diseases for which they have low immunity and a mortality rate above to the national average, it was presented before the STF the case ADPF 709. For the plaintiffs, it should be recognized the omission of the government in creating a special policy for indigenous health in the pandemic. The STF, in hearing this case, acknowledged the urgency of the case and ruled in order to impose on the government a set of measures, like the creation of sanitary barriers that prevent the entry of non-indigenous on their territories, the extension of protection to the indigenous living on lands with pending official approval, and the order to create an assistance plan for indigenous people with the participation of the National Human Rights Council and representatives of indigenous communities. That kind of decision represented an attempt to block the continuous practice of disregarding the indigenous lives, mainly when it happens by omission. The third case is related to the federal system in Brazil. So, following the negationist script, President Bolsonaro didn't take any substantial measures in the coordination of a national engagement in favor of social distance, such as prohibition of parties, restrictions on circulation, closure of schools, and so on. Therefore, at the beginning of the pandemic, state members and municipalities started to rule on these issues in their respective territory to protect the people against the dissemination of the virus. The president, looking at these acts in opposition to his negationist perspective, created embarrassment in the implementation of the state and municipal orders. That was the moment when the court was called to intervene. In the case ADPF 672, the STF confirmed that state members and municipalities may take control of the situation against the spread of the virus without violating the competence of the union, as the three of them, the union, state members, and municipalities, both the three actually, are equally competent to act and rule on the protection of health, and the president, represent the union, cannot remove the decisions of the other federal entities. The same conclusion was present in the case ADI 6343, when the STF stated that state members and municipalities don't need authorization of the Union to adopt policy measures in response to the COVID-19 pandemic. That case represented a great change in federalism jurisprudence in Brazil because it gave more powers and independence to municipalities and state members than to the national government. In conclusion, after this very short panorama, which hasn't the possibility to cover all the STF cases, I would say that the task of safeguarding constitutional rights not an easy one. And that task become more difficult in times of pandemic crisis across the world. In Brazil, these three cases show us that violation to human rights can adopt different strategies. The omission one represents the worst scenario, mainly when officials are elected to run, to govern, and then to act in the execution of the Constitution. It seems that the Brazilian president preferred to non-act in this way. Although the STF institutional challenges we have been denouncing for a long time, the STF as an institution is worthy, regardless the performance of its temporary members. Separation and independence of powers is still necessary. And safeguarding the constitutional pact is the only political way to improve our human rights in a democratic society. That is the task is open to be decided for us Brazilians soon. So I hope to thank you again for the audience to be in part in this panel, and we are super grateful for our guest today, which is Professor Marieta Safta. For her, I leave the room for her talk. So thank you so much, and I think we have a great discussion in this topic today. Thank you so much.
Professor Jairo, thank you very much in my name, in the name of Compedi, clear as the sunlight as usual, and we have for sure some questions and good discussion. Thank you very much. And our special guest, Professor Marieta Safta, if I remember, Bine Ativenit, if I remember.
It is really perfect, yes.
Well, very welcome to our panel and to the Compedi, the first of several ones that we pretend to invite you and to be back in Brazil, not as a tourist. I know you've been, as you said, in Brazil twice before, but as to participate in our events like the Compedi one. So the mic is yours, the room is yours, Professor Marieta, and thank you very much again.
Hello everyone, bom dia a todos e todas, which is in Romania, bună ziua tuturor. Professor Rubens Besac comments in our previous discussions that our languages are similar. So you pronounced very well, bine ai venit. So thank you very much for the invitation. It is really an honor to be here today. Thank you very much, Professor Jairo Lima, for the invitation. Thank you very much, Professor Rubens Besac. It is always a pleasure to meet you, and we have a fruitful dialogue And I remember a few months ago in a conference in Romania, we've discussed with Professor Jairo Lima some developments in the case law of our courts, Romanian constitutional courts and also the Brazilian Supreme Court, regarding the state of emergency and the measures determined by the COVID pandemic in our countries. And also we published an article in this on this topic. And right now in my presentation, as Professor Jairo Lima added as well, I will try to add more information and developments under the topic COVID-19 lessons, constitutional, political, and social threats and challenges, of course, Romanian experience. Let me try to share my presentation to be more clear. I hope that is processing right now, so I hope that
we have to wait a few seconds.
Yes.
Otherwise, okay, it's running. Okay.
I would say that these 2 years in Romania and all the world states experience a global pandemic.
Professor Maria, I couldn't see your presentation. Jairo, can you? No. Oh, yeah.
Right now?
No,
right now?
that's okay.
Yes.
That's okay.
Yes. I started because I've seen that something is processing there, and I hope that is successful. So, as I said, these years, when the world states experience a global pandemic, have changed our lives in many ways. After 2 years, it is said that we have returned to our everyday life, but is this a return? What have these 2 years meant in political, social, and economic developments? How has this pandemic affected the governments and citizens' actions, and how do these transformations significantly influence future results? In my presentation, I will approach the constitutional perspective of these challenges and developments concerning Romania in European and global context, emphasizing landmarks aimed to the nature of constitutional balancing during declared emergencies, an assessment of emerging related to governmental responses, an understanding of the core constitutional structural and right-based issues at stake in COVID response, and in the end, the importance of the digitalization in the new world. As concerns the first point, the nature of constitutional balancing during declared emergencies. We know that the fight against pandemic determined to take exceptional measures in all states of the world. And such measures usually introduce additional limitation on fundamental rights and freedoms and may affect the normal functioning of the state institution. Usually in such situation, the executive authorities receive increased powers to respond quickly to the crisis situation, and the balance of power thus become a real challenge, which brings to the fore the importance of the legal mechanism established for their protection. The constitution of the states contain a variety of regulations regarding the regime of exceptional situation and the competencies of the authorities in relation to them. This variety of regulation also reflected in the variety of solutions adopted in the context of the pandemic. The constitutions and the fundamental laws usually establish the powers of public authorities in exceptional situations, as well as in some cases detailed rules on the state of emergency. And I give you some examples in this regard. As for Romania, the constitution provides the concept of state of emergency, but we don't have a clear definition in the constitution, just in the law. Provisions regarding the level of the regulatory act that governs the legal regime of the state of emergency and the competent authorities to adopt or order measures in that situation. And also, of course, the Constitution regulates the conditions for the restricting the human rights and freedoms, and mechanism for ensuring the check and balances, including the constitutional review, which in our system is the European model of constitutional review, the Kelsenian one. Just few words about our constitutional courts, because even there are some similarities in terms of the effect of the decision. For example, we discussed in our previous meeting about the similarities between the constitutional review in Brazil and constitutional review in Romania. There are also important differences in this regard concerning the organization and functioning of the court, and also the powers of the court. I would say that the constitution adopted in 1991 after the fall of the communist regime and revised in 2003 provides the regulation of the constitutional court in a separate title, Title 5. Created according to the European model of constitutional review, the Constitutional Court of Romania is, according to our fundamental law, the guarantor of the supremacy of the Constitution and the only authority of constitutional jurisdiction. So it's not a court of law in a traditional meaning, it's a separate institution. In fact, this is the specific of Kelsenian model of constitutional review. In this respect, the Romanian system of constitutional review differs from Brazilian one. I have here some reference to your doctrine in this regard. The Constitutional Court of Romania was established in 1992, and the first decisions were delivered in the same year. Recently, in fact, we have celebrated 30 years of Constitutional Court. In 2003, following the revision of the Basic Law, the Constitutional Court's role was consolidated and the legislator entrusting the court with new powers. At the same time, the authority of the Constitutional Court was strengthened. And the decision, according to the Constitution in force, the decisions of the courts are generally binding. In this sense, I've mentioned that the role of the court was consolidated in 2003. Here you have the powers of the court, which concern the constitutional review of the laws before promulgation, after the promulgation, so the law in force, the review of the treaties or other international agreements, the review of standing orders of the parliament. Also, the court have the power to solve legal disputes of constitutional nature between public authorities at the request of the President of Romania, one of the President of the two chambers, the Prime Minister, or other President of the Superior Council of Magistracy, to guard the observance of the procedure for the election of the President, and other powers which is related with the role of the President of Romania. Also, an important power of the Constitutional Court is to establish the constitutionality of the laws for the revision of the Constitution. I remember that is also an interesting discussion in your system as well. The Constitutional Court of Romania was notified during this period to rule on several cases in which acts of legislative power, the parliament, the Romanian parliament, and the executive power, the President of Romania and the government, were challenged. The main issues addressed concerned the observance of constitutional conditions regarding the powers of these authorities in relation with the restriction on the exercise of certain rights and freedoms. In this context, the Constitutional Court of Romania ruled upon the competence of the legislative and the executive regarding the declaration of the state of emergency and the state of alert. Here you have the main point of the decision of the court regarding the power of each authority. The Parliament has the power to enact by organic law the state of emergency. The President has the constitutional prerogative to declare the state of emergency and to enforce the legal provisions. The Parliament a posteriori After the enactment of the decree by which is declared the state of emergency has the obligation to verify the fulfillment of legal conditions regarding the establishment of the state of emergency. And as concerned the decree of resident of Romania, the court mentioned that can be subject of two-stage review. A review exercise ex officio by the Parliament of Romania, and a review exercise upon the notification of the subject provided by the law by the Constitutional Court. This is the legal regime established the first time in this period of the decree of the President of Romania, by which is established the state of emergency. As concerned the restriction of human rights and freedoms, I would say that at the beginning of the pandemic, the sanctions provided in Romania for violating the imposed measures were particularly drastic, and the control exercised by the public authority was very strict. You have here some examples. Sources from the media. In only 2 months since the beginning of the pandemic, you see how many sanctions had been applied and how many criminal cases have been drawn up. And in this context, these acts that led to the application of these measures were the first target, I would say, of the referrals brought before the Constitutional Court by the advocate of the people through the exceptions of unconstitutionality. The advocate of the people criticized the ambiguity of the rules with regard to the sanctions, which allowed the discretionary conduct of the agents, and the lack of proportionality, and, more important, the unconstitutionality in itself of the restriction of the exercise of fundamental rights and freedom by government emergency ordinance. In fact, this is a sensitive issue in our country, this regime of government emergency ordinance, because sometimes there is an abuse of the executive in using this procedure, with a special procedure provided by the Constitution to enact some regulation. Basically, the Constitutional Court was called to decide on the interpretation and enforcement of Article 53 of the Constitution, which provide the rules regarding the restriction on the exercise of certain rights or freedoms. You have here this article. The referrals brought before the court and the related debates focused in particular on the concept of law, which is provided by this article. Because according to the Constitution, the restriction of the exercise of rights or freedoms may be realized only by law. But what does it mean, the law? This was the main question. According to the court, the concept of law, which is contained in Article 53 of the Constitution, must be approached in the narrow sense as an act of the Parliament. So not an act of executive, like government. As a result, the court has sanctioned the restriction on the exercise of fundamental rights and freedoms by the government emergency ordinance. And the court stated that the act which restricts and affects citizen fundamental rights and freedoms or fundamental institution of the state can only be a law as a formal act of the Parliament adopted in compliance with the Constitution. As concerned the proportionality requirements that must be observed regarding the restriction on the exercise of constitutional rights and freedom, the Constitutional Court ruled that the criticized provisions impugned and found as being unconstitutional, not only do they not concretely provide the facts that incur the contravention liability, but they establish for all these facts, regardless of their nature or gravity, the same main contravention sanction. So the court decided that it's a problem of proportionality and the clarity of the law there. After this decision of the court, was enacted the law on some measures to prevent and combat the effect of the COVID pandemic, which is the actual framework for the restrictive measure. Also, this law was challenged before the Constitutional Court. As concerned the understanding of core constitutional structural and right-based issues at stake in COVID responses, I would mention like main example, the decision regarding the mandatory hospitalization and the requirement of protecting individual freedom. The Constitutional Court examined a referral submitted by the advocate of the people and allowed in part the exception of unconstitutionality and found that the provisions criticized are unconstitutional because these legal norms affect individual freedom, free movement, and intimate family and private life. Why is this? Because, according to the court, giving the relevant minister, the Minister of Health, the responsibility to supplement the regulation on the conditions under which persons with contagious diseases are required to declare, receive treatment, or to be hospitalized, as well as the freedom to amend at any time and without complying with certain limits, the criticized provisions acquire an unpredictable, uncertain, and difficult to anticipate character in contradiction with the provision of the articles of the Constitution comprising the conditions regarding the quality of the legal norms. Also, the court invoked the Article 5 of the Convention for the Protection of Human Rights and Fundamental Freedoms, and also the case law of European Court of Human Rights. This case law is mandatory in Romania based on Article 20 of the Constitution. We have special provisions in this regards related concerning the relation between the national norms and the international treaties on human rights. Referring in the same context to the national framework regarding the measures of non-voluntary hospitalization, the Constitutional Court mentioned that these measures is regulated in detail, both in criminal matters and in the law on mental health and protection of persons with mental disorders. And these laws provide warranties in line with the Constitution and Convention. But the situation in that orders of the ministers are different. As regards the criticized provisions, the court found that they refer to some hypotheses that the legal text mentions above do not cover, namely the one in which hospitalization to prevent the spread of disease can be arranged without the person's will and without guarantees. Concerning the lack of quality and confusing nature of the regulation, the problem was raised in the same context of the increase of the number of sanctions and the amount of the fines applied by the police. And the court upheld the exception of unconstitutionality raised before the advocate of the people, noted that the norms do not concretely stipulate the facts incurring the liability, but they establish a general obligation to comply with the law under the undifferentiating task of the heads of public authorities, legal person, as well as natural person. That is why the court found that also that provision is unconstitutional. Also, the Constitutional Court found the violation of the right of access to justice by the fact that the person concerned to challenge a government decision or order issued under the law, the new law, cannot identify the procedural regulation so as to comply with them. In fact, there are not special regulation to provide an effective access to justice. Referring to European Court of Human Rights case law regarding the strong connection between the requirements regarding the clarity and predictability of procedural legal norms and the exercise of the right of free access to justice, the court noted that the simple general reference implied by the analyzed provisions of the law with regard to the provisions of general law in the matter under the conditions in which the regulation of the law are expressly excluded for the application does not meet the conditions of clarity. And my last point, which I think it's a general problem, concerned the importance of the digitalization, and I wonder if we discuss about a new way of life, because the adaptation to the restrictive measures adopted during the COVID pandemic has led to a remarkable acceleration of the digitalization process in many areas in Romania, and I think in all the countries of the world. The difficulties are more obvious in Romania in the case of institutions such as Parliament, because legislators' very operation is based on the assembly of many people together. But in order to adapt the activity of the Parliament to the new conditions, the rules of the Senate was amended, introducing a new article according to which the sessions of the plenum of the Senate will be held by electronic means. But a group of senators notified the Constitutional Court with this decision, arguing inter alia that the new procedure does not provide any of the democratic guarantees provided for the Constitution regarding the functioning of the Chamber of the Parliament. But the court rejected this case, the referral, noting that even in the event of the state of mobilization, state of war, state of siege, or the state of emergency, the meeting of the plenary and standing committees do not take place automatically by electronic means, but is necessary that by their nature, the event that follow or another during the state of mobilization, the state of war, the state of the siege, make impossible to the presence of the parliamentarians at the Senate headquarters. Such power of the Standing Bureau to establish a rule like this does not concern the exercise of national sovereignty or the exercise of sovereignty in its own name by a group constituted in the Standing Bureau of the Chamber. On the contrary, the decision to hold the plenary meetings by electronic means is a technical and urgent measure that ensures the continuity and the functioning of the Parliament, a required premise for the exercise of national sovereignty by the Parliament. Otherwise, stated the court, Parliament would be prevented from exercising its constitutional role with direct effect on the Article 2 of the Constitution concerning sovereignty. And the courts of law has to adapt their work, as you know very well. Whatever we are talking about traditional constitutional justice, we have been to identify to ensure that the resolution of the cases continues while respecting both the restrictive conditions and the fundamental rights and freedoms of the citizens. In Romania, the digitalization of some activities in the judicial system was necessary anyway, even without the constraints induced by the pandemic situation. But this context has led to additional pressures, prioritizing the choice of digital solutions that have led a desired modernization of justice. Beyond the challenges regarding the resources, the coherence, technical compatibility of the identified solution, the fundamental issues that arise in this context is the observance of the rule of law, understood as a set of guarantees associated with justice and fair trial. Here you have a situation of the courts of law in Romania. All of this information are public because they are mentioned in the decision 19 per 2022 of the Constitutional Courts. This information are provided at the request of the court in that specific case where the court decided on a new procedure introduced to in order to facilitate the judgment through this kind of new equipped of judiciary right now. So, according to the information provided by the Ministry of Justice at that moment when the court pronounced this decision at the beginning of the year, within the 238 courts of law, the number of courtrooms of council chambers and the hearing chambers of undercover witnesses amount to be about 1,044. Among these, 903 are equipped with video conferencing system, and the number of 296 are to be equipped in the near future. It was outlined that by a project proposed for being financed through the National Recovery and Resilience Plan, it is provided acquisition of 600 video conferencing system and a lot of other details regarding the situation of the logistical capacity of the judiciary at that moment. During the pandemic, it was established by law that in civil cases where possible, with the agreement of the parties, the courts of law may decide that the hearings be held by audiovisual telecommunication means that allow the verification of the party's identity and guarantee that security, integrity, confidentiality, and quality of transmissions, providing the necessary measures for this purpose. But after that moment, the intention to make this solution permanent led to adoption of a regulation proposing that upon the request of the offender who filed the contravention complaint, with the approval of the court of law, the court hearings on the merits and appeals take place exclusively through audio-visual telecommunication system that allow the verification of the party's identity and guarantee the security, integrity, confidentiality, and quality of the transmissions, the courts of law providing the necessary measures for this purpose. If the offender who filed the contravention complaint is requested to be tried by audiovisual telecommunication system, all procedural documents in that case shall be communicated exclusively by email. The hearing of other persons, witnesses, or experts shall take place through the same audiovisual telecommunication system. But by decision 19 from 2022, the Constitutional Court found the unconstitutionality of this law. Why that? Because having examined from the point of view the challenges formulated in the referral, according to which the law does not govern whether and under what circumstances the court of law may reject the offender's application, the court held that the assessment to be made by the court of law in approving the request measures aims in essence at two kinds of issues, technical and legal. The technical assessment does not require special regulation as it involves the examination of clearly determined conditions having an objective nature, the existence or not of an infrastructure necessary for holding court hearings. But the legal assessment, given the scope of the law, is one with a high degree of complexity, imposing a precise regulatory framework. However, the law does not establish criteria for the court of law to be able to decide whether or not to approve the offender's request to hold court hearings exclusively through audiovisual telecommunications system. Thus, in accordance with the challenges formulated, the court noticed that the approval of the request for judging cases on contravention matters by means of audiovisual telecommunication might be established by a clear and precise regulation circumscribed to the requirement imposed by Article 20 of the Constitution in conjunction with Article 6, the right to a fair trial from the Convention for Protection of Fundamental Rights and Freedoms. This conclusion, I would say that the test of pandemic highlighted from a constitutional point of view recurring problems such as exceeding the limits of legislation by the government through emergency ordinances, lack of quality of legislation sanctioned by the Constitutional Court. The context of the pandemic determined also a rising of awareness regarding the importance of fundamental rights and freedom from both the population and also the authorities. As regards in particular constitutional reviews of constitutional courts, we note that the court itself had to adapt its activity to the conditions of pandemic and to fulfill its constitutional role even in these extreme conditions. But constitutional court continued its activity, adapting it according to this period. In concluding, as concerned the digitalization of the judiciary, I think it will be a long process, which will be completed through dialogue and debate, public-private partnership through cooperation between the Ministry of Justice, Superior Council of Magistracy, and in this regard, I can conclude that the crisis is a kind of disruption, but also a catalyst, I would say, for the evolution of the society, because there were a lot of changes in regards, mainly in this field of the digitalization of some activities, and especially in the field of justice and activity of public authorities. Here you have some information regarding the activity of the Constitutional Court of Romania. You'll find there, if you are interested, some summaries of the main decisions of the court, the main decisions pronounced in this period concerning the pandemic. And also we have the Constitutional Court bulletin published also in English and posted on the website in order to ensure the widest possible access to information it contains. Thank you so much for your attention. Thank you.
Thank you very much. I congratulate you, Professor Marieta Safta. It was a complete presentation and very interesting to know the situation, the judicial responses in the Romanian courts. I'd like to congratulate both of you, Professor Jairo, Professor Marieta Safta again. It's very interesting to see some visions in such countries very distant away, each one of us, but it's very interesting to see the judicial responses, how they differ. I'd like to open for questions, comments. I'll start by myself. If you see that you can answer me, it will be a pleasure. It will be the same question to Professor Jairo and Professor Marieta Safta. Because in Brazil, as you know, we live in a federal country. It's a very typical federation divided in three spheres of influence. The counties, we call them in Brazil municipalities, the states, and the federal district, and the union. And Romania is a non-federal state. And I have a link, I'm related to the University of Salamanca in Spain, and Spain is between the two of the systems. It's a community country, or a state of communities. They say estado de comunidades. It's something between the non-federal state and the federal state. Do you consider the federal system, or being in a non-federal state, is related to the responses that we have in the judicial system? I'll make an example. I was doing during the hard months of the lockdown, trying to make a postdoctoral study in Salamanca, which I belong to. And I saw situations very odd, like some neighbors being fined to walk away for more blocks that they were allowed to, 10 blocks and not 2 or 3 blocks, and fined in 8 grand euros, something very difficult. And those decisions being turned down by the Supreme Court 2 or 2.5 years after that. And but the allegations by the Spain Supreme Court, being more precise, the Constitutional Court, was something like, no, this is not a state decision putting the fines, 8 grand, something like that. It was a community, for instance, Castilla y León decision, and it's not, there is no constitutional stuff to doing that. How is the situation in Romania? I saw your presentation, I listened for that, but do you see the federal system allow us to make more efficient responses, I mean judicial responses to the enforced laws, the enforced fines, put it in the lockdown month or during the pandemic? And Jairo, how you see the situation in Brazil? Because we changed the constitutional understanding that the health was a problem divided into the 3 partners, the 3 spheres of influence in the constitution. And when we saw the union doing nothing by denying the pandemic in the presidency of Bolsonaro, we saw our Supreme Court, the Supremo Tribunal Federal, saying, okay, the union is doing nothing, so the states, they are allowed to act in the name of the union. How do you see the situation? If I don't know if I was very clear, but I'd like to know your opinion. So, please.
Thank you very much for your question. It's difficult to compare that two systems. I think since we don't have a federal system, the things should be less complicated here in our state. And as concerned the review, the review of the acts adopted by the authorities, the competence is well established. We have the competence of the Constitutional Court concerning the constitutionality of the laws and emergency ordinances, for example. And as concerned the administrative acts, we have the competence of the courts of law. I think the difficulty in terms of number of cases in this period was in the system of traditional courts, because a lot of files were submitted there. I think there are a lot of cases right now. But as I said, the competencies are well established. But your question raised me other idea. We have a different challenges here in Romania and in other countries in European Union, because the system of European Union is closer to a federal system, even if European Union is not a state, is not a federal state. But we have a kind of multi-level system of constitutionality in European Union. We have the national level, we have the level of European Union, and we have also the level of the Council of Europe in terms of the legislation for the protection of human rights, for example. And sometimes it's difficult to connect all these levels, to establish a coherent interpretation and application of all these guarantees offered by the national constitutions, by the European Convention of Human Rights, and also the Charter of Fundamental Rights adopted at the level of European Union. And sometimes tensions appear. I think it's an interesting topic, and in this context, I would like to ask you also something. If there are some kind of tensions in this regard between the national level of constitutional review, for examples, and the regional level of constitutional review, like Inter-American Court of Human Rights. It would be very interesting to know if there are similar problems in these two systems. And thank you very much that you remember me this topic. And it would be a pleasure for me to invite you, if you have time and if you want to join, to a debate at the ICON conference in this regard. We have a forum there concerning this topic, if you like. Thank you very much.
Thank you, Professor Marieta. I'll give the word to Jairo, but just to answer Professor Marieta, it will be a pleasure. I'll be at ICONS also. I have a few days. I'm sharing a group, but it will be a pleasure. Just check the date. It will be a pleasure to be with you again. And I would say in Brazil, we have states courts, but they don't give the exact role of checking the constitutional problems. They check for sure, but only the constitution, the state's constitution, at the level of the state's constitutions, not the same role as the Supremo Tribunal Federal, the national court in Brazil. So we have several justices in Brazil. I would say there is a state justices, 27 states justices related to directly to the Supremo Tribunal Federal, and we have a federal justice also related to a tribunal called Superior Tribunal de Justiça, and then the STJ, STJ related to the Supremo Tribunal Federal. It's very complex. It's something very Brazilian.
It's very complex, yes.
It works. I'm not criticizing. It works, but it's very complex because we have a triple level system of the Federation Brazil. But it's different because persons from other countries imagine that in Brazil we have, like the US, constitutional courts in each state, and we don't.
Yes.
We don't. We have Tribunais de Justiça, but it's completely different. So we can come back with the question in ICONS on other meetings. And thank you very much. Jairo, please, the mic is yours.
Thank you, Professor Ruben, for your question. In terms of what are the implications of the case on federalism in Brazil? I would say that we cannot deny the fact that case was decided by the influence of the political scenario of that time. The time there was the chief of executive branch didn't taking measures in terms to support or to prevent the spread of pandemic, and then the case was issued to the STF. There was at the time a strong social media pressure in terms of we should do something in terms of restrictions, in terms of quarantines, and the governors and the mayors in municipalities and state members, they started to do something in terms of restrictions, in terms of taking care of the health system of the people. Because people used to say here in Brazil, people, they live in the cities, they live in the municipalities, they don't live in state members, and they don't live in the union. So mayors, as the first political offshore in the community, they were pressured to take measures against COVID, and they started to do that. That was the reasons underlying this case. But this case is also very important because before Brazil used to have a national government-oriented jurisprudence. The jurisprudence of the STF in terms of federalism, they used to be very centralized in the national powers of the union. So they used to tend to confirm, to support, or to improve the powers of the union in contradiction with the power of the member states and the municipalities. Mainly, for example, in the tax system in Brazil, policy matters, they were very much concentrated in the union powers. So this case tried to change this orientation and trying to decentralize the powers to the state members and to the municipalities. The great challenge, I think, posed by this specific decision of the STF is related to the future cases. In other words, after pandemic, will the STF keep this more decentralized jurisprudence on federalism? That's a question that's open for us, because if STF keep this jurisprudence, we will have many change in terms of, for example, the distribution of money, the distribution of budget among the federal entities, among the union, the state members, and the municipalities. That's the question, I think, that this kind of decision poses for us. What's going to happen before pandemic? Because you know that this decision was very contextual. It was about the political context we were living at the time. And in the near future, this decentralized movement will remain in our jurisprudence. That it's a thing that we are waiting for new answers quite soon. And we hope that the STF has could have a good performance in this kind of jurisprudence. And I hope that I could be clear in this answer. And I would like to enjoy that we still have time. I would like to question Professor Marietta, if it's cool for you. I would like to Professor Marietta to congratulate for us for this presentation. As common, you are always so clear and instructive in your talk. And I would like to listen you a little bit more about the case on Article 53, I think, on the state of emergency in Romania. You told us that the question underlying that case was the interpretation of the word law. In other words, how fundamental rights could be restricted, what this law means. I'd like to listen you a little bit more. What was the argument, the most important or the leading argument the court used it to support or to defend the idea that law in that case was just enacted by the parliament? This is the first question. And the following one, in the same topic, do you think that in other cases, I'm supposing that the Romanian Constitution has other provisions with the same word, law, I think. I'm not sure, but I'm supposing that there are cases in the Constitution saying this law. Do you think that in future cases, in other provisions of the Constitution text, which has the same word, law, do you think that the court would say the same, would say that law for the constitutional text is just enacted by the parliament? Or you think that this was an exceptional case because it's a matter of fundamental rights restrictions. So we should be very narrow in terms of interpretation. What do you think about it? Do you think that the court will keep this jurisprudence, or it was, as in Brazil, just a very contextual decision in terms of pandemic? And thank you again for your speech.
Thank you very much. Yes, thank you, Professor Rubens. Thank you very much for the question, because you give me the opportunity to explain better this issue. In fact, I think there is a textual interpretation and also a systematic interpretation in order to have this decision of the court. When the court decided on the meaning of the word law in the Article 53 of the Constitution, the court also uses the argument of Article 115 concerning the legal regime of the emergency ordinances of the government. Because this kind of acts of the government, in terms of the issues they solve, they are the level of the law, but not in any condition the government can adopt this kind of legislation. The delegation, the legislative delegation, is expressly provided by the Constitution in this Article 115. And according with this article of the Constitution, the emergency ordinances of the government cannot be adopted in the field concerning constitutional law. So, of course, the government cannot change the Constitution, just the parliament. And this kind of act can't affect the status of the state fundamental institution or any rights and freedoms. So there is an express provisions there in Article 115, according to which the government can't affect the human rights. So the courts said, okay, it is about the law, but it is not possible to have in mind the generic meaning of the law, regulation. Because, look, according to Article 115, the government cannot affect the fundamental rights. This is, in essence, the argument of the court, and that's why I think there will be coherent interpretation in the future and not one contextual or something like this. And as I said, there are a lot of discussions regarding these emergency ordinances. In fact, we had also a referendum concerning this kind of regulation. The president asked the people if they accepted to restrict more the powers of the government to adopt emergency ordinances. And the people said yes. We want to restrict more this in order to not issue emergency ordinance in the field of justice, for example, and criminal laws. This was the will of the people. But we don't have a change of the Constitution in this regard. There were some proposals, but the new parliament renounced to that proposal. We'll see in the future. Thank you very much.
Thank you so much, Professor Marieta.
Thank you. As I talk to the backstage, to Jonathan, that I congratulate by the help, a very constant help. I see there is no other questions. And this is to thank again Professor Marieta Safta. It was a pleasure to have you here with us in the Compedi. In Brazil, for instance, a virtual meeting, but you are invited to be with us all the times in person. And Professor Jairo Lima, a special friend, again, a very good presentation. and the state of your research. So thank you both. It was a pleasure for me, in my name, in the name of Compedi, and I thank our great audience. They are putting in the general chat, congratulations. They are very concerned about the state of the problems linked to the pandemic, and the presentations give us some lights about what we were doing abroad. And thanks again. Thank you, everyone. And it's a beautiful morning here in São Paulo. I don't know in Bucharest. I don't know in Londrina. But have a good day for everyone. And thank you very much.
Thank you so much. Thank you so much.
Thank you. Multuresque.